Well, good afternoon. Welcome to today's session. My name's Al Roberts. I'm the Rappaport Professor of Law and Public Policy here at Suffolk Law, and it's my pleasure to welcome you to today's discussion. And Fred Amon, the Dean of Suffolk Law, and Susan Prosnitz, the Executive Director of the Rappaport Center for Law and Public Service, join me in welcoming you today. The Rappaport Center is a new component of Suffolk Law, and it was established with the generous support of Jerry and Phyllis Rappaport. And one of its objectives is to cultivate public discussion on critical issues of law and public policy, which of course brings us to today's discussion. Today's session is organized as part of the mid-year meeting of the American Bar Association's section of Administrative Law and Regulatory Practice. And we're grateful to Russell Frisbee, the section chair, and Renee Landers and Paul Afonso, the meeting chairs, for their help in organizing today's session. The title for today's session is Managing the Bailout, Execution and Oversight of the Federal Response to the Financial Crisis. By the way, I have instructions to tell you at this juncture that if you're here for the child support session, that's actually in the next room. This is support for a different class of dependents. It's probably not necessary for me to motivate the importance of today's discussion, but let me tell you a bit about its scope. Our aim is to examine the challenges of policy, design, execution, and oversight that are posed by the Troubled Asset Relief Program, or TARP, that was approved by Congress just 4 months ago. And as you know, the conditions under which TARP was designed and implemented were truly daunting. Extraordinarily high stakes, intense time pressure, and great uncertainty about the character of the problem to be addressed. And so the questions we've got before us today are, first, how well the design and implementation challenges have been handled, and second, whether the oversight mechanisms established since October of last year have proved effective. Of course, as we address those questions, we've got in mind the fact that TARP's successor was just unveiled on Tuesday. If you go on the blogosphere, you will see there's already active debate about whether we should refer to this as TARP 2 or Son of TARP. I'll leave this for the panel. We have an outstanding panel here to talk to us today. You've got detailed biographical notes being circulated, so I'll just introduce the panelists briefly from left to right. Bob Hoyt, who served as General Counsel at the U.S. Treasury from December 2006 to January 2009. Damon Silvers, Associate General Counsel at the AFL-CIO and a member of the TARP Congressional Oversight Panel. Tom McCool, Director of Applied Research and Methods at the Government Accountability Office and GAO's contact point with Treasury for TARP-related issues. Bill Kroener, Counsel at Sullivan and Cromwell and co-chair of the ABA Task Force on Financial Markets Regulatory Reform. And Professor Hurley, who's Director of the Morin Center for Banking and Financial Law at Boston University School of Law. And here are the rules of the game. I've asked each of our panelists to speak for 10 minutes, and then we'll use the balance of our time for question and answer. And before I get going, I would just ask you to turn your cell phones off to avoid disruption during the presentation itself. So then, without further ado, let me turn it over to Bob. Welcome to Boston.
Thank you. Thank you, Alan. Thanks to the ABA and to Suffolk Law School for having me here. I've been out of Treasury, I guess, for 11 days now. So as I was saying to Damon and Tom, who I've been seeing on a regular basis over the past few months, I just couldn't resist getting back into the fray. So I'll just start off one with a little disclaimer. So I'm not the General Counsel of Treasury anymore, so I'm not speaking on behalf of the Treasury Department. You'll excuse me, I hope, if I say we or other things like that, because I've not, frankly, completely disengaged yet. But even if I pretend to speak for Treasury, I'm not. And Tom can verify that. What I thought I would do for my 10 minutes is talk a little bit about the context in which not just the Emergency Economic Stabilization Act was passed and that the TARP programs were started to be rolled out, but even some of the events that came before that. And the reason for that, you'll see as I get to the end, is I think that some of that context, while everybody either lived through it or has read about it in the newspapers or has suffered through it watching the value of their portfolios decline, I think it's very easy to lose sight of what was going on in the marketplace and in the financial system in the fall that led to these programs. And in my view, it's a very important part of how one needs to judge whether the programs have been effective, and a very important perspective from which oversight has to follow. Also, I thought for me to stand up and say how effective the programs were and how great the oversight was might ring a little hollow. So I thought I would introduce it this way. So let me just start by going through a little bit of a timeline. And some of this is the perspective of what we were seeing at Treasury throughout 2008. And I'll cover the first half of 2008 in a very quick summary fashion. But there are just sort of two indicators that I'll refer to as I go through this timeline that are viewed by some people as being indicators of stability or creditworthiness of banks or the financial system. One is called the LIBOR-OIS spread, and it's essentially the premium that is charged for lending to banks. And as banks are viewed as being a riskier credit, that number goes up. And as they're viewed as being a less risky credit, that number goes down. The other is a similar measure that goes institution by institution called the credit default swap spread. And again, the higher it is, that is the premium being associated with the riskiness of the institution. And so if you go to the beginning of 2008, LIBOR-OIS spreads were at about 8 basis points. And that's essentially where they were in the 7, 8, 9-point range that was the average for 2006. The average for 2007, and that's where things stood at the beginning of 2008. And if you looked at CDS spreads for broker-dealers such as Morgan Stanley and Goldman Sachs, they stood close to zero. It was really negligible spread. For banks, they tended to be around 50 basis points roughly. They varied a little bit depending on the institution. In March, obviously, you have the collapse of Bear Stearns, a great shock to the marketplace, and I think to most Americans and observers. Just to give you a sense, after the collapse of Bear Stearns, the LIBOR-OIS spread jumped from that 8 basis points to 55. So by an order of magnitude, a pretty significant jump. And credit default swap spreads went up to about 200 to 250 basis points for banks, and about the same for broker-dealers. In April, you saw, this may resonate with many of you here, you saw the market for student loans seize up. Many of the lenders that participated in Education Department loan programs were withdrawing from the market, refusing to make the loans. And that was startling because these are loans that are 97% federally guaranteed, and still that market had completely dried up, such that the administration needed to seek emergency legislation, which was enacted by Congress in May